Hello and welcome to Workers' Compensation Claims Management, Investigating Disputed Claims. My name is Sharon Poston. I'm the president of ESM Solutions. We are a risk management firm that assists employers with managing their workers' compensation risk. We've partnered with Bowermaster and Associates to provide injury prevention and claims management services. Thanks for joining us today. This is the first in a two-part series to discuss questionable or disputed claims. Today's discussion will address what an employer can do to investigate questionable claims. The second webinar of this series will discuss how employers can manage denied litigated claims. What is the basis for compensability of a claim under workers' compensation? And what does AOE-COE mean? That's what we're going to be discussing in this webinar. There are statutory affirmative defenses for denial of a claim. What are they? There's a deadline of 90 days from the employer's knowledge for the carrier to deny a claim. What happens during that 90-day window? And what steps should an employer take to manage any disputed claim? It all starts with your accident investigation. Accident investigation is one of the 8 required elements of your Injury and Illness Prevention Plan, your IIPP. The purpose of your accident investigation is twofold. First, it's for prevention. What was the root cause of the accident or incident, and how can you prevent that from happening again? And secondly, does your investigation uncover any inconsistencies or areas of concern about whether or not the injury is work-related? For a claim to be compensable in California workers' compensation, it must satisfy 2 criteria that are abbreviated as AOE-COE. An injury must arise out of employment, and it must occur in the course of employment. The claim can be questioned on the facts of the alleged injury, or based on medical causation of the injury, or it may be a legal question, say an issue of coverage. Who was the carrier during a particular time? For a claim to be, in the claims arena, we call these areas of concerns red flags. They are issues that you uncover during your accident investigation that lead you to ask the question, did this injury arise out of and in the course of employment? Is it compensable under workers' comp? Let's take a look at some of these red flags. First, is there a conflicting description of accident? Maybe the injured worker tells you the injury occurred one way, tells the supervisor another story, and maybe the doctor another story. That's a red flag that there may be something else at play. The injury was reported late. Maybe it was reported on a Monday and said that it occurred on a Friday. It even could be reported a week or 2 weeks or a month late. If it's reported that late, there needs to be further investigation. Maybe the injury was not in the course of job duties. Could the person have been on the way to and from work, or maybe had stepped out for lunch? What else was happening that made you think that it didn't occur during the job duty requirements? Perhaps the injury was first reported after termination or layoff. Maybe the job duties don't support the mechanics of the injury. Or there's hearsay of maybe other non-work-related causes. You know the employee was in a motor vehicle accident recently, or they're active in athletics, or they played soccer over the weekend. Something that makes you think there could be some other causation. Or perhaps the injury was reported after a disciplinary action. You are the eyes and ears for the insurance carrier if you question a claim. During your investigation is the time to begin working as a team with your claims adjuster. Phone conversations should be followed up with emails to the adjuster, confirming your conversation and to ensure that your concerns are thoroughly investigated. So make sure you notify your insurance carrier or your claims handler of any information regarding your concern, disputes, or other personnel or disciplinary actions that are in play. Request in writing, and this could be via email, that a disputed claim be delayed and investigated. Those are the words you should say, because delayed means something to the insurance company, and we'll talk about that in a moment. So when you question a claim, that's your direction. Please delay and investigate. And then follow up consistently and frequently with the claims handler during that 90-day delay period. Sometimes the information that you fail to provide is information that can change the outcome of an investigation. So even if it's hearsay, that should be reported as well, and you should simply state it as fact. I have heard from another coworker this, and then statements could be taken from that coworker if necessary. There are certain processes and deadlines that the insurance company must follow, the claims handler. Once you, the employer, questions the claim, the carrier then sends out a delay of benefits letter. And that delay letter is due within 14 days of you reporting the claim. During the delay period, up to $10,000 will be paid in medical coverage or until the delay is sent. And that would be paid for by the insurance company through your premium, through your policy. Then the carrier begins to conduct an investigation. It may be an internal investigation in which the claims handler takes a recorded statement of the employee. It could be an external investigation where an outside investigator is assigned to come to your place of employment and interview several employees and the injured worker and yourself. This whole discovery period takes place within a 90-day window because the denial letter, if one is to be sent, must be sent within 90 days from your first notice. That's the employer's notice. So if you are aware of a claim and you don't report it for 30 days, then that means the carrier only has 60 days to investigate. So the more promptly you can report disputed claims and have them questioned, the longer the carrier has to conduct their investigation and discovery. While I strongly encourage you to have your insurer delay and investigate any questionable claim, I also want you to know that frivolous delay of paying for claims is prohibited. In California, there is a liberal construction labor code 3202. The workers' compensation judges are mandated to liberally construe the law in favor of the injured employee. So when you're thinking about whether a claim should be denied or not, take a look at what the facts are and what the ultimate result will be. Make sure that this is not a frivolous denial, but one that can be upheld. There was a recent piece of legislation signed into law by Governor Brown on September the 18th called Senate Bill 863, a major reform in California. And this should also be considered when you are conducting your investigation, because if a claim is denied and the employee begins to treat with a doctor who is not within the medical provider network, the MPN, you as the employer may lose your ability to control medical treatment if the claim is later determined to be compensable. So those two things should be taken into consideration when you are evaluating and deciding whether or not a delayed claim should actually be denied. The 90-day discovery period should be a team effort and involve ongoing discussion with your claims handler. Is there a basis for denial of the alleged claim? What's the ultimate exposure of this case? Is temporary disability being authorized by the doctor? Is permanent disability anticipated? What treatment is taking place, and are there medical liens? And is state disability paying under EDD with liens filed that are accruing? What is the basis for the denial? And what is the strength of the denial? These are two questions that you can ask your claims handler. Often a claim will be denied on a provisional basis because the 90-day deadline is approaching or because the employee has not returned the signed medical authorization forms. These are fairly weak denials. What else is the claims handler doing to move the case forward? And what are you, the employer, doing to stay in touch with the employee and encourage him or her to meet with you to discuss the work status and potential job accommodation? So make sure you consider, is this a case to deny, or is this a case to accept and manage by managing the employee return to work and manage the medical care? Don't assume that the claim handler will know all that you know. There are many assumptions that could be made of these particular facts. Let's take a look at them. This is a case study of a 46-year-old journeyman plumber. He's been a plumber for 15 years. On April the 6th, it was his last day of work. He was laid off due to reduction in force. On June 9th, he files a claim, a cumulative trauma, or CT claim. The first notice of claim comes from an attorney alleging elbow injury from repetitive work. On July 4th, the claim is denied because there was no medical evidence to support this injury. We do know that there were some medical records that were found that did indicate there was treatment prior to the layoff for his elbow. So what should you do? Well, as I mentioned, there are many things that could be assumed from the facts of this case. Which ones are correct? For example, maybe this employee only worked for you for a short period of time, or maybe he had a different job. What would you say if you were the judge with just these facts? A long-term plumber with an elbow injury? No, it sounds like a probable result of his employment. But what if the facts are different? What if he only worked for you for 1 week? Maybe he was just hired as and asked for a helper because of a prior injury. He could have said that to you. Or what if he was hired as a non-laboring foreman for a short project? So he really didn't do any physical labor. The possibilities are endless. So make sure that your claims handler knows the facts that apply to this particular case. And then take a look at what's the total exposure, what are the odds of prevailing on a denial, what is the potential of settlement now versus protracted litigation, and continue to follow up with your claims handler until resolution. Labor Code Section 3600 does list some affirmative defenses that are the basis for denial of a workers' compensation claim. Intoxication, or post-accident positive drug testing, a self-inflicted injury, suicide. I mean, some of these seem obvious. I did, unfortunately, have a suicide case one time in which the employee was fired for a sexual harassment charge. He came back on the property the next day with a gun and actually shot himself on the property, and it appeared that he had some intention of perhaps shooting others there as well. So was that suicide a result of his employment or not? It's not always as clear as you think it would be. Altercations, the initial aggressor is not covered. A felonious act, if an employee is in the act of committing a felony and is injured, that's not covered. Recreational activities that are voluntary, if you support a baseball team and your employee plays on that team, he's probably not covered if an injury occurs. So these affirmative defenses should be raised if they occur in the course of a claim that is alleged. I mentioned earlier that some denials are considered weak denials. Here are some examples of that. Lack of cooperation. Maybe the employee refused to return the signed medical authorization form or refused to give a recorded statement. Really all the employee has to do to turn this into an accepted claim or to pursue the claim is to fulfill those two things. So that's a fairly weak denial. Statute of limitations is a fairly weak denial. Although the statutes do state that it's 1 year from the date of injury of knowledge that a condition is work-related, often that 1-year statute is not upheld at the Workers' Compensation Appeals Board. Going and coming rule as a basis for denial. There are many exceptions. While you're generally not covered in your commute to and from work, there are many exceptions to that rule. So make sure that those have been fully explored if these are the basis for the denial. All right, let's see what you remember. Can you answer this question? A questionable claim can be denied at any time. Is that statement true or false? That statement is false. A claim must be denied within 90 days of the employer's knowledge. If it is not denied by the insurance carrier or the third-party administrator, TPA, by the 90th day, then the claim is deemed compensable. There is an exception that if there is evidence that becomes available that could not have been discovered within the 90-day window, let's say, for example, a witness comes forward with evidence that the injury occurred while the employee was playing baseball, then the claim could be denied after the 90-day deadline. I'll conclude with these final thoughts. Make sure that you actively investigate all claims. Delay and investigate questionable claims for possibility of denial. And then stay involved with the claims handler as the claim progresses to acceptance or denial. Even if the claim is denied, continue to provide modified or alternative work for the doctor's work restrictions. Deny claims that are not compensable under workers' comp. Assess the most probable outcome of a denial and litigation, and then push your claims to early resolution. A denied litigated claim that we'll be discussing in the next webinar usually doesn't get better over time. So please join us for a discussion of the steps you can take to ensure that your claims handler is defending you against denied litigated cases. Thank you for participating today. Please give your account advisor at Bowermaster a call if you have any additional questions or need assistance with a questionable claim. I'll leave you with a few websites that may give you additional assistance. Thank you again for joining us. Goodbye.